What is the quote American rule?
Sure. So you need a lawyer. I mean, I'm a lawyer, so yeah, I'm biased, but you're hearing these rules. Get the rule book. Yes, you can represent yourself, and many whistleblowers have to. And many have used this book and its predecessor, the Whistleblower's Handbook, to win their cases. So yes, you can proceed on your own. Maybe you have no choice but to proceed on your own. But ultimately, get a lawyer, but get a lawyer that understands whistleblower law. And then you have to figure out how you're going to pay for this lawyer. So in the reward cases, because rewards can sometimes be very large, many whistleblowers will work on what's known as a contingency. They'll take 1/3 or 40%. So if it's $1 million reward, they can make, 400,000. So they'll take the case just like they would a personal injury case, your typical slip and fall case where the lawyer takes 1/3, because there's a possibility of getting a large verdict. But now if you have an employment case and the whole case is, say, $100,000 in damage, 1/3 of that is $33,000. It's not even close to the amount of hours and time a lawyer would have to put in to win that case. I mean, you can get stat fees that run up into over the $1 million just for the fees alone. So whistleblowers have historically had a very hard time finding lawyers to represent them in an employment case. So one of these reasons is what's known as the American rule, which each side pays for their own lawyer. Okay, it's kind of simple. If I lose, I don't pay the company's fee, and if the company loses, they don't pay my fee, just everyone walks. So in 1976, Congress passed the Civil Rights Attorneys Fee Act. They recognized that this rule prohibited most victims of discrimination from getting any lawyer. And it altered the American rule, and it says that if you win a discrimination case, the company pays your fees. And they pay your fee at market rate. And the market was viewed as the market for complex litigation because civil rights needs intent, motive, and they're hard cases to win. So what that means, market rate. If the whistleblower can't afford a lawyer, is paying $10 an hour, and you win the case, but the market says it's $500 an hour, the whistleblower gets paid $500 an hour, even though their contract said $10 an hour. And also, they can't create a sub-market for do-gooders. So if there are lawyers who specialize, say, in civil rights cases, but they take these cases on for $100 an hour on the average, so the market for the civil rights lawyer is $100 an hour, but for the similar type of law, complex litigation, the corporations are paying $700 an hour. You can't create this sub-market of poor lawyers that discourages highly competent people from getting involved. So that lawyer, even though they're, most civil rights victims are paying $100 an hour, can still get the $700 an hour. A lot of lawyers don't even understand this, and most clients don't. I read all these cases all the time. They say, well, I had a retainer agreement of $1,000. So I won, give me my $1,000. I mean, that's ridiculous because retainer agreements don't count. They don't count because anyone could put anything in a retainer agreement. You look at the market. And by driving the market value to lawyers who represent whistleblowers, they can get paid a very good fee when they win the case. It also incentivizes them to put in the time and energy to win the case, because that's how they get paid. So it's a win-win for the good guys, and it prevents corporations and the wealthy from using their economic advantage to hire really good lawyers where the whistleblower doesn't even find one.